Welcome everyone. We have a very, very special show for you today in a partnership with KRO 23 ABC and Kern Stiles. We have a panel of experts here joining us today in the practices of personal injury and workers' compensation. You can have your questions answered today. Just if you're joining us, you're on either Facebook or YouTube, type in a question and we'll be sure to get your question answered today. As I mentioned, the two main practice areas we'll be talking about today are personal injury and workers' comp. Kern Stiles also has expertise in civil rights, elder abuse, and a few other practice areas. So again, just write your questions down. First and foremost, my name is Jorge Barrientos. I'll be the moderator today for this panel. And joining us today, I'll go around the table really quickly and introduce the three expert attorneys we have joining us today. To my immediate front, we have Matthew Clark. Matthew Clark is one of the rising stars at Kern Stiles. In fact, Super Lawyers magazine has acknowledged him as such. He's also been recognized as a people to watch from Bakersfield Life magazine. And of course, very importantly, he is a community advocate here in Kern County, sits on a handful of boards, and including MAD Kern County, Mothers Against Drunk Driving Kern County. Matt, welcome.
Thank you very much, George.
To his left, we have James Yoro. I think he would say that any of you can call him Jim, right, Jim?
Sure.
All right, and Jim has been working in workers' compensation for nearly 40 years. In fact, he is state certified in workers' compensation, and they don't just give those certifications away, do they?
You got to earn it.
You got to earn it, definitely. And there's a lot of workers' compensation lawyers in town. Not all of them are state certified. Jim Yoro is, in fact, certified. He's also the past president of the Kern County Bar Association and was recently recognized as by the U.S. World News and Report as the best lawyers in America. Congratulations on that.
Thanks, George.
Okay, to his left, we have the head honcho, David Cohn. He's the managing partner of Kern Stiles. David, Mr. Cohn, has nearly 45 years of experience in workers' compensation law.
Personal injury.
I'm sorry, in personal injury law. Thank you, Jim. And it's safe to say that you've been there and done that, right?
A few times, George.
A few times, more than once. And he, as well, was also recently recognized U.S. World News and Report Best Lawyers in America. Congratulations.
Thanks, George.
So with that, long story short, these are your three local experts here today, focusing on personal injury and workers' compensation law in Bakersfield, fighting for Kern County residents, Bakersfield residents in those practice areas. And with that, let's get into it. First question.
Sure.
How do I know if I have a personal injury case? What are the keys there to recognize it?
You want me to start? You guys want to start, or who wants to do it?
Well, as Matt is wont to say, you've got to have three elements in any personal injury case. Number one, you have to have what we call liability. Most people know that as fault. We want to have a case where the other party is clearly at fault. Number two, you have to have damages, and the damages are in the form of a personal injury. And number three, you have to have collectability. If there's not an ability to collect damages from the person that injured you, you're probably not going to have a case that's going to go very far. So those are really the three important factors that you have to have in any personal injury case.
Gotcha. Anything to add to that, Matt?
Well, what I tell people a lot is that the collectability factor is a big issue, right? Because if you have the first two elements, liability and damages, you have a case. You can file a lawsuit and you might very well get a judgment, but all you'll have is a piece of paper that says somebody owes you money, and now you have to try to collect on that judgment, right? And that's really challenging. I mean, I can tell you based on my own experience in the practice for, 17 years or so now, that collecting on an uninsured judgment is a challenge. And so that collectability factor is an important thing. It's something that we analyze each time a new client comes in to see us.
And as Matt said, what we're primarily looking for in a personal injury action, whether it's an automobile accident, whether someone trips or slips and falls in a business, there has to be that element of collectability. And what we're really looking for is insurance. Because the average person is not generally going to be able to pay out on a claim. So we're obviously looking for an insurance because that is the best way to be able to collect damages for our clients.
Yeah, and that's I think that's a misnomer that a lot of people have, right? It's you know, I don't want to sue this person. I don't want to sue that person. You're not necessarily suing that person, right?
Well, technically,
You are.
You absolutely are, but a lot of people think we sue the insurance company. We're not suing the insurance company. We're suing the individual or the company that may be at fault for the injury. But ultimately, it's an insurance company, or in the case of a really large corporation, you know, that's where the damages are going to come from.
Sure.
And in an auto accident case, unfortunately, in Kern County, that oftentimes becomes problematic because we all know that there are people out there that are driving around who are uninsured.
And I imagine we're going to talk more about that
We will.
specific issue, George. But let me just add this last element, and then I imagine you'll have something for Jim. You know, if you take a step back, we've talked about these three elements: liability, damages, and collectability. But what are we really trying to do in this process? We're trying to make you whole, right? We're trying to take you back. I like to tell people that if we could take you back to the moment before that accident occurred and put you in the same position you were in at that time, then we've done our job. Now, there's no magic wand. I can't wave a wand and make your injuries go away. If, God forbid, you've lost a loved one, we can't bring that loved one back. But the goal is to make you as whole as we can. And the law only has one mechanism for that: money, right? It's a financial mechanism. And so you've got to have that collectability factor in order to have a viable case.
Gotcha. And let me correct myself. I didn't necessarily mean, of course, the plaintiff, you know, suing the defendant, which is the person, but nobody's losing, for example, a house in most cases.
Yeah, you know, it's funny though. It's pretty rare that I have people who are worried about that issue, right? I mean, oftentimes that's not really given much thought by my clients. And
Gotcha.
I don't know about your experience, Dave, but every so often it comes up, but it's not, you know, typically speaking, you know, the client's pretty upset because somebody did something wrong to put them in that position, and they're not really concerned about whether or not, you know, you're suing them as an individual.
Well, depending on the case and depending on the severity of the injury, I mean, at times, you know, clients want some form of punishment to happen to the person that injured them.
Exactly.
And look, it's only human nature that you might think that way, but our goal is, as Matt said, is to make our clients whole. You know, the idea that we're going to go out and necessarily punish the person that injured them, and that's really not what we're about.
Gotcha.
We just want our clients to be fairly compensated for what happened.
Perfect. Jim,
Yes.
is there we've been talking about personal injury law, which is, you know, of course, car accidents and whatnot. What about work injuries? Is there a different process there that people should look out for, the steps that they should take?
The workers' compensation system is different from the civil litigation system because the state of California established a program of workers' compensation starting back in the early 1900s, which provides for benefits to people who have been injured at work. So essentially, it's a no-fault system, and it's also supposed to be an administrative process, so there's no juries that are going to be involved. There are going to be some administrative law judges, but supposedly the system is to provide benefits. It's a benefit delivery system. Unfortunately, the complexities involved in workers' compensation law have increased over the years so that for most people, they need to get an attorney at some point. So while Matt and Dave are concerned about fault, liability, compensability, in the workers' compensation arena, what we're really looking at is, have you suffered an injury, and did it happen at work or in the course of work or because of work? And we're not talking about just injuries. We're also talking about, have you contracted a condition or an illness that could be related to the job duties or activities that you were involved in.
What kind of examples can you give us about?
Well,
some of
for
this?
example, the typical warehouse person is out in the back, they're stocking product, and they bend over, pick up some heavy product, and their back goes out. In a situation like that, you don't have to prove that somebody's at fault. You've just got to establish I suffered an injury, and it was while I was doing my job. So that can turn into a workers' compensation case. And of course, the other is if you contract a disease. Say, for example, you are a, what do they call those people who draw blood?
Phlebotomist.
Phlebotomist. There
Yeah.
you go. You could be a phlebotomist, and one of the vials of blood that you're drawing breaks. You happen to contract possibly hepatitis or HIV as a result of that, and need to get medical treatment. That is as a result of your job. Therefore, it's a potential workers' compensation case.
You know, the thing that's more common here, Jim, and you should comment on this, is valley fever. I know in your practice
yeah.
you've been very successful in getting workers compensation after they've contracted valley fever from their job.
You know, Matt, that is a problem that a lot of people don't recognize and understand, and that is the Central Valley is a hotbed for valley fever. You know, the Center for Disease Control has identified our location as one of those places where it is rampant. And when people work outdoors, remember, valley fever is caused by a spore that exists in the dust. So when that dust is disturbed and potentially contains the spore, it can be inhaled and thus cause some very serious consequences. So anybody who works outdoors, construction workers, highway people, people picking up garbage, or for that matter, you could be just working outdoors as an elementary school teacher when a dust storm comes up. So you need to be cognizant of that.
So, Jim, how difficult is it to prove or
Yeah,
make the
it's a great
connection?
question, because it's not easy.
It isn't. And you know what we have to rely on are two things. One, the medical timing, and number two is we have to get what's called a medical legal evaluation. That is an expert who can correlate the timing between an incident such as a dust storm and when the symptoms first appeared, so that we can show that in this location, at this time, this incident occurred, this person started contracting or started showing symptoms, and we can kind of backtrack to that. Also, another way that we've been able to establish it is, for example, as you both know, the Cymric leases out there by Taft, there are numerous cases of valley fever that occur out there. So oil field workers, agricultural workers working out there, all they need to establish is they were working out in an area where this has been very, very common. And then number two is that they were engaged in some kind of activity that would have kicked up dust. And so
Jim, in terms of the damages that a person can receive in a workers' compensation case, for instance, in a personal injury case, you know, our clients are entitled to reimbursement of medical bills if they've lost time from work, lost wages, general damages, or what a lot of people know as pain and suffering damages. I mean, those are typical types of damages in a personal injury claim. Are those remedies available in a workers' comp case?
And that's one of the challenges of my practice, and that is because the benefits that are available in workers' compensation are defined by statute, and those are temporary disability, permanent disability, medical treatment, because remember, our system is no fault. So you don't have to establish that somebody caused this to occur.
Right. As I understand it, part of the grand bargain when the workers' compensation system was instituted, and in fact I believe they called it the grand bargain,
Exactly.
was that in exchange for this no-fault system, we would alleviate employers from the obligation of paying general damages,
Right.
or what we call non-economic damage, or for Dave and I in our personal injury cases, pain and suffering.
Exactly. So the benefits are defined, but they're supposed to be guaranteed.
Yeah.
If you get injured on the job, you can get these benefits. You just have to establish to what extent you were injured, to what extent is your permanent disability, and your need for medical treatment. But I have a question for the two of you, and that is this.
We're taking George's job, by the way.
Yeah, we are.
George, you might as well get out of here, man.
Yeah,
well,
let me interrupt you for just a second for the people that might have joined us a little late. We're joined here by Matthew Clark, Jim Yoro, and David Cohn from Kern Stiles, answering your questions that you may have.
George, you didn't introduce yourself.
I am Jorge Barrientos. I am the Director of Marketing and Public Relations at Kern Stiles. Thank you, Matt.
You're the guy that makes us look good,
Yeah,
Yes.
I try to, right?
which is a real challenge
No,
with this
it's
crowd.
not. But you touched on something towards the end there, which was the medical component of it. You know,
Right.
I think a lot of people, first and foremost, they're injured, you know, whether it's in a car accident or at work.
Right.
And the first thing they're worried about is, I need to get better, right? Whether it's to go back to work, to take care of my family, whatever it is. Can you explain to people how that works, either of you, as far as getting better and making sure you get the medical care that you need?
In a personal injury case? Or
Sure.
in
Yeah,
a
let's start with
workers'
personal
comp?
injury.
Well, you bring up an excellent point, which is when clients first come in and see us, what's their immediate concern,
Exactly.
right? And 9 times out of 10, that immediate concern is, oh my gosh, I got to get medical care so I can get better, so I can get back to doing the things that I like to do, right? I can work, I can take care of my family, I can have quality of life. And oftentimes, and you know, our medical system, I think, is really impacted, especially in this community. I think both of you would agree with me. I mean, it's getting treatment timely is sometimes challenging. And so that's something that I know Dave and I guide our clients through that system. And using the services that are available, right? Your health insurance, number one. I mean, I can't tell you how many times I have a client come in on an auto accident case, and the first thing they want to know is, well, shouldn't I be running all of my medical care through my auto policy? And it's like, oh my gosh, do not do that. That is absolutely the wrong way to go about it. You have health insurance for a reason. And I can get into the complexities of this, but your health insurance has a capitated contract with the health providers in your network, so you ultimately pay less for the care, okay? And so you want to treat through your health insurance, but that is a big first question that we get asked all the time.
Well, and it's oftentimes a struggle to be able to guide our clients to get the right kind of medical treatment. I mean, clients sometimes on their own have their own ideas as to what's the best course of action for me, and oftentimes it may not be. And with our expertise in initially evaluating what the client's injury is, you know, I like to think of myself as kind of a facilitator. I know Matt does, in terms of trying to guide the client to the proper medical person for their treatment. Who, not only who's going to provide them with the best level of care, but who's going to be able to present that injury in such a way that we're able to maximize the benefit to our client at the end of the case. Because remember, ultimately at the end of the case, as Matt said earlier, we want the clients to be fairly compensated, and unfortunately sometimes some of the medical providers that we're very aware of in our area do not necessarily, you know, help enhance the value of the client's claim, and they're not really good at you know, demonstrating what the client's injury is. And you know, at the end of the day, we are going to have to present to an insurance company, you know, this is the client's injury, but we have to back it up.
The flip side of that, by the way, is there are some excellent medical providers, and we can help sort of guide people as to who to go to and who to see.
But always an important question for me, and I know some of my clients will often ask me, Jim, well, if the workers' compensation system is a no-fault system, and I'm going to get medical treatment, and I'm going to get temporary disability, and I'm going to get permanent disability, why do I need a lawyer if the system is this no-fault system?
It was designed as a no-fault system. Unfortunately, the way it's executed creates problems. And I can pretty much tell you the problems usually start with the insurance carrier's response to a particular claim. Because even though it's no fault, they can still disagree that this injury actually occurred in the course and scope of your employment. They can contest the fact that you need medical treatment or that the level of your disability is as bad as you believe it is. And so more often than not, they need to contact an attorney because the insurance carriers are not providing what they should be providing. And in terms of medical treatment, you know, I have to go into a little rant here. It has become so problematic in the workers' compensation system now because recent changes in the law have pretty much handed over total control of medical treatment to the insurance carrier, which makes it very difficult because not only does the insurance carrier get to choose who the limited group of doctors are that you can get your treatment from, they also have a system where they hire another group of doctors to review the decisions of the first doctor, and in essence, they can say no and say, no, that's not reasonable and necessary, and then the only thing you can do is appeal to another group of anonymous doctors regarding, can I get this treatment? So the process has become delayed.
But Jim, you and your
very
team, and I know this because you and I have a lot of cases that overlap. I know Dave does as well, and we should talk about that in a moment, the significance of that overlap, right? But I know that you and your team are oftentimes successful when a client who has an injury that falls in the scope of the workers' compensation system, you're able to guide them to care that they might not otherwise have received.
Absolutely. That's one of the things that we can do is to try to get you to the people who can get you back to work, which leads me to the question that I was going to get back to, and that is this. Because your system in civil litigation allows you to expand the scope of damages to make the people whole, whereas my system doesn't really make them whole, there are certain cases where we can actually work together, right? Where somebody suffers an injury. So
and that's actually one of the things that makes our firm, and George, you know this as well as anyone, that makes us so unique because we have experts in personal injury as well as workers' compensation all under the same roof, and we can work together when there's a case that involves both a personal injury and workers' comp. And Dave, why don't you explain what that is?
My average guy who gets injured in the oil field.
I'm happy to do that, but one thing I think we need to make clear for our audience is this. A lot of times when an injured worker is sent out for medical treatment, it's very clear to me that there are certain medical clinics in Bakersfield who basically try to either diminish or totally wipe out the injured worker's injury. Because, I mean, let's be honest, these doctors are being paid by the insurance company. They're on a list that's established by the insurance company, and when it really comes down to it, they wouldn't be on that list if they're not trying to help the insurance company. So they have an incentive to basically minimize the injury to our clients. I mean, wouldn't you agree with that?
There are a lot of those kinds of clinics, more prevalent in the Southern California area in Los Angeles, where the insurance companies have a very strong foothold there. Here in Kern County, we don't have as much, but we also have more of a choice that allows us to get people who can provide the kind of care that our clients need, even though they know it's a challenge because the insurance company still has the opportunity to review those requests for treatment.
Before we go on to this first-party, third-party issue, because it's a lengthy discussion, I mean, do you have anything you'd like to talk about before that?
Well, really, I'm looking at our comments here online, and for everybody listening and watching out there, please feel free to ask your questions on the Facebook page. There's a lot of interest in workers' comp.
Their questions will be far more entertaining than yours.
Well, you have no idea.
Yeah, no kidding.
You have no idea. There's some pretty interesting questions here.
Okay.
That we can talk about on the air?
Well, not all
Are
of
we going to
them.
have to censor some?
Definitely not all.
What I want to
right.
know is how much are people picking on us? That's
Yeah,
what I really want
no,
to know.
not so much. There is,
Not so
there are a
much.
few.
We'll see. We'll see.
But workers' comp is definitely something that's that people are interested in. And again, comment if you wish. We have 3 attorneys here from Chan Cohn Stiles answering your questions. we'll dive a little bit more into some of this stuff, but just to ask and answer one of these questions, this person says you get hurt on the job and denied medication, surgery, physical therapy. What should that person do in that case?
More likely,
Well, they're not going to be able to do it on their own.
That's right.
what I'm
Yeah,
sure.
that's short answer. They're going to have to talk to an attorney about that.
Okay, perfect. Well, you heard it first right here. The second question is, how much time do you have to file a claim? And it's not specific as to what type of claim, but let's start with personal injury. How much time do you
that's a very tricky question.
So
It depends.
it depends. If you are in, let's say you're in an auto accident with a private party, that's typically a 2-year statute, 2 years from the date of your injury.
However, if the case were to involve something like, say, drunk driving, right, which we see a lot of, okay, then you have the potential for punitive damages. Well, the claim for punitive damages has to be filed within 1 year of the date of the accident, okay? And then to further complicate things, if the owner or the driver of that vehicle that hit you, I'm going to stick with the auto accident hypothetical here for a moment, if the owner or the operator of that vehicle happens to be in the course and scope of employment with a public entity, the public entity claim must be filed within 6 months of the date of the accident. So it is a very tricky question. The answer that I would give to the viewers is this. If you're involved in an accident of any kind and you have a question about when you can file the claim, just call us right away.
I mean,
because you're better off being safe than sorry, because you can blow that statute of limitations, and at that point, you can never file.
Got it. What about workers' comp? Does it make a difference?
The answer is the same. It depends. Because depending on what the nature, scope, and extent of the injury might be, the statute could be 1 year if it's pretty specific. It could be quite a bit later if it's a continuous trauma, meaning that over the course of your work, you've engaged in activities that are slowly deteriorating your condition.
The back injury cases.
Correct. Or carpet layers who can't remember a specific date that they may have hurt their knee, but just doing that kind of work over
Continually
the course of time.
over a long period of time.
So
and
they would have until the very last day of their employment to potentially file a claim, as opposed to a specific where you fell out of a truck, then it's 1 year from that date. And then there's one other, and that is if you contracted a disease, but you didn't know about it for a year, 2 years, and then somebody says, you just contracted a disease. By the way, this is mesothelioma. Did you put up any, asbestos or anything?
Gotcha.
So it's different.
And our office handles quite a bit in the way of elder abuse cases.
Correct.
In elder abuse cases, it's a 1 year statute of limitations. And one of the problems that we run into is oftentimes, unfortunately, an elder abuse case is resulted in somebody who's passed away, so you've got a family that's grieving, and they don't come to us right away. And, once you come in and see us, it takes a period of time for us to gather the full medical records so that we can really analyze the case. And a year goes by very quickly under that circumstance. So you really need to act quickly and contact a lawyer quickly.
And really, that goes without saying for almost any kind of case. I mean, number one, if a potential client contacts us, there's no fee to sit down with us and talk about your case. So basically, you have nothing to lose, and better to be informed early on. There may not be a case, there may be a case, but if you come to us early on, we're going to give you the best information that you can provide us, and we'll analyze that. There's no charge for that.
Gotcha. I have another question here from a viewer or listener, and again, if you're listening out there, we have 3 attorneys here from Cohn Stiles ready to answer your questions. Why does my case take so long? Why do cases take so long?
Oh, that's
So there's no, first of all, one of the questions that I'm asked about half the time when I'm meeting with the client for
how long is this going to take?
How long is it going to take? And my answer, and I try to answer in a conservative fashion, I mean, look, are there occasions where cases can resolve quickly? Yes, that happens. That doesn't happen often, and there's a variety of reasons for that. But generally speaking, in the county that we live in, you're looking at somewhere around 18 months for resolution.
And we're really fortunate. We're in a great county where we have really good access to the courts. We have 3 judges who are totally their caseload is basically totally devoted to handling civil cases. And
There are counties in California where you could wait 5 years.
And you know, these judges pride themselves on moving cases through the system as quickly as possible. But just as an example, I was in court this morning where the judge had set a trial date in 2020.
Jeez.
Yeah.
But that's kind of the rare case. I mean, Matt's right. I mean, usually I like to tell clients I tell them anywhere from 18 to 24 months, which really sounds like a long time for us because of the work we're going to always be doing on the case. That's actually kind of quick.
Yeah, and there are things that lawyers and us in particular can do to speed that process up. There are things that other lawyers may do that drag the process out, by the way. So, for example, if somebody comes in and sees me and they've been involved in a severe accident, the accident was, say, somewhere between 0 and 30 days ago, 1 and 30 days ago, right? There are certain lawyers out there who would just drag their feet until the statute of limitations approaches, be it 1 or 2 years, and then file a lawsuit, and then they start the 18-month calendar, right? We take a different approach. It's an aggressive approach, but it's if you come in and you have a case and that case justifies filing an immediate lawsuit, we file it. I mean, there are days, and it even shocks me that we're able to pull this off, but there are days where I'll meet with somebody in the morning, and by the end of the day, I have a lawsuit filed.
Wow, that's pretty quick. Let me address a few questions here that we're getting that have kind of been addressed already, but the questions came in a little late. We have, let's see, if I get injured at work, but I was at fault, am I still covered? We covered that, of course.
It's supposed to be a no-fault system. There's only one exception to that, and that is if you did something that was intentionally reckless in terms of safety.
Is it fighting an exception to that too?
There's a couple of exceptions to that, but if, say, for example, you laid out some rebar and you didn't do it correctly, and then you trip and stumble over the rebar that you incorrectly laid out, you still got a workers' compensation
Gotcha.
case.
Go ahead.
But if you've got another question, I wanted to get back to that third-party question because I think it's
Sure, just
Well,
really
let's
quickly.
take another
Just
question.
really
Go ahead.
quickly, this is just addressing a medical malpractice case. And of course, I'm sure you guys would recommend actually reach out to an attorney that specializes in medical malpractice.
Right. We don't handle medical malpractice cases, but we're certainly willing to, if you call us, we can try to direct you to someone that does. And I will say this, when we talked about the statute of limitations,
That's a very tricky
it's
issue.
very tricky, and I mean, it's generally a 1-year statute, but again, if something happened at Kern Medical Center, which is a county facility, which is a governmental facility, the 6-month statute that Matt talked about absolutely applies.
Yes, thank you very
And
much.
there's usually a crossover, right? So in our elder abuse cases, there oftentimes can be a medical malpractice-like component to that. And so that's something else that we keep a very close eye on.
Perfect.
Yeah, I mean, they're not cut and dried. We really look very carefully at what the earliest possible statute could be, and then that's what we're going to go by.
Perfect.
Got any other questions, George?
Well, plenty of questions, actually. So we'll get to those. Again, if you're listening and watching right now, we're joined by 3 attorneys from Cohn Stiles. Please do write your questions, and we'll do our best to answer them. If we don't get to them on the air, we'll definitely get to them off the air. But moving things along, and how about we cover a topic that encompasses the third party as well, and that's something that's very common and something that Cohn Stiles handles, and that's car accidents.
Okay.
So let's talk about car accidents. We talked about insurance. First and foremost, if somebody is injured in a car accident, it's somebody else's fault. Let's even throw the person is on the job driving and then somebody hits them. What do you do?
That's the perfect hypothetical.
And I had an opportunity to represent a really nice fella who was riding his motorcycle down 23rd, and a lady who worked for the county pulled out in front of him, and he got injured. Well, that's a case. That's a 6-month case against. We were going to file that 6 months with that statute of limitations, but assume that my client in that case had been on the job at the time when that car pulled out.
Well, and we have plenty.
And
of
we
those
have
cases.
those cases as well.
I can think of a case, it rings in my mind for various reasons, but you and I together represented a man several years ago driving a cement truck. And he was in the course and scope of his employment. Course and scope just simply means you're on the clock, you're doing your job, okay? And he was driving a fully loaded cement truck northbound on Highway 99 when he got into an accident with a tractor trailer, okay? The tractor trailer had changed lanes in front of him and caused an accident. And so in that particular type of case, you actually have two cases, okay? You've got a workers' compensation case,
correct,
and then you have what we call a third-party personal injury case that either Dave or I handles. And the thing that makes us unique, because we do have workers' comp and PI under the same roof, is we can work together to maximize the recovery for the client, and that can be quite complicated.
Because sometimes what will happen is we'll have clients come to us, and they want us to handle the personal injury aspect of their case. They have a different lawyer who represents them in the workers' compensation case. Well, sometimes we may kind of be working against each other because we want that client to receive all the maximum medical treatment that that client deserves, which sometimes might not necessarily be what the workers' compensation lawyer is doing on the case. And so it's such a luxury for us to be able to handle both the personal injury part of the case and the workers' comp part of the case, because we sit down and we strategize in terms of how's Jim going to handle the case and how's that going to affect the personal injury case, because they absolutely each affects the other in terms of what happens down the line.
Yeah, I mean, Jim and I, this is getting pretty down in the weeds, Jim, as far as the legal issues, but we're constantly having conversations on our cases where there's a workers' comp component and a third-party personal injury component about how to, maximize the recovery to the client by minimizing repayment of, say, a workers' compensation lien, or to eliminate a workers' compensation credit. I had a case earlier this year. It was a very sad case. A young man was unfortunately in an accident that took his life on the highway. He left behind a very young daughter, and Jim did just a heck of a job getting this young girl a fairly substantial workers' compensation benefit. It was going to pay her out all the way up until she's age 18. Well, if I settle the personal injury case and money goes to that little girl, that money could have acted as an offset against these benefits that she's getting until she's 18. So Jim and I, in coordination with each other and in coordination with the workers' compensation carrier, was able to craft an agreement so as it didn't cost that little girl those future workers' compensation benefits.
Well, and I think more importantly, it's being able to coordinate the medical with each other.
correct,
because oftentimes we might suggest, Jim, this might be a better medical approach than what you might normally do in just the workers' compensation case. So, the freedom to be able to do that
And just yell down the
Right.
hall at each other, which
is,
is
And
nice.
it's terrific.
What's important is that people out there don't know exactly whether their case is a personal injury or a workers' comp, because they're not paying attention to that. All they're paying attention to is, I got hurt at work, but if you were on an oil rig and a pipe fell on you, it could be that somebody else was responsible for how that pipe fell, and it's not your employer.
Well, in fact, look, many times the biggest cases we have in the office is exactly that situation. We've got an oil field worker, whether he's a roustabout, whether he's on a drilling rig, a production rig, and
Or a subcontractor.
or a subcontractor, and another contractor, not his employer but somebody else, does something and our client gets hurt, yes, we've got not only the workers' compensation case, but we've got the case against the employee's company that injured him, and that oftentimes is certainly the more valuable case.
Well, we're able to collect, and again, going back to sort of where we started this discussion, in the personal injury side of the case, we're able to collect those non-economic or general damages, or what we call pain and suffering, right? And unfortunately, in the comp context, you just can't get that.
Sure.
And that oftentimes can be the biggest component of the case.
Well, and more than that, Jim's clients get temporary disability, which is a formula that they use, but there's a maximum amount of money that the injured employee is going to be able to collect under the workers' comp system. In a third-party case, the part of the case that we handle, at the end of the day, that injured employee is going to be entitled to receive full compensation. So if somebody was making $4,000 a month, well, he's not going to get $4,000 a month in the comp setting. But at the end of the third-party case or personal injury component to that case, that injured worker is going to get that $4,000 a month back from when he got hurt up through the time that we get that case resolved. And that's pretty meaningful, obviously, in that situation.
And George, I don't want you to think it's limited. I mean, we've used the oil industry and the oil field industry as an example, but I mean, it's across all industry lines. I mean, I have delivery drivers, right? Delivery drivers who may be injured because there was something defective on a loading dock. Well, they've got a first-party workers' compensation case, while they simultaneously have a third-party case against whomever it was that owned that dock, that had that the reason that the dock was dangerous. And so it really goes across all industries. I mean, it never ceases to amaze me when I think I've seen it all. I think we can all say that. We always see something new.
Oh, look, yesterday was a perfect example. I saw a fellow who got severely injured on a construction site. He worked for the general contractor. They had a concrete pumping company out there. The operator let some air get caught into the pumping hose. The hose ultimately whipped and hit my client so hard it shattered his hard hat, and he was unconscious for a long period of time and has been going through rehabilitation because he suffered a severe injury to his brain. So not only does he have the workers' compensation component to that case, there's going to be, I think, a very good case against the concrete pumping company because they failed to do the right thing out there.
Jim and I have had a couple cases where people have been injured in cardboard baling units.
Right.
They've got a workers' comp case because they're on the job baling cardboard.
Yeah.
They also have had, in those cases, claims against the companies that have maintained those baling units because that's the reason they failed. It was improper maintenance. We've had cases, and I think that this is oftentimes overlooked, but it's something that we're always looking for, where somebody's injured on the job because of a defective product, right?
Or a piece of
Good-
machinery.
A piece of
point.
equipment
That's a
or
really
a
good
defective
point.
product.
Well, before we go dive too deep into the defective products, we're talking about motor vehicle accidents, which, of course, are the most common. And, I mean, you guys are talking about complicated stuff here, right?
Right.
That sometimes a lot of people don't know, and they try to work with their insurance on solving some of these issues. In fact, I have somebody here commenting, and for all of you listening out there, please comment. If we can get to your question now, we will do our best to answer them. Otherwise, we'll get to them offline. But I have one person that says, I was involved in a motor vehicle accident with my children, and the other party hasn't reached out to me at all. What can be done? There were injuries involved and damages. So it sounds like this person hasn't quite, or maybe is trying to work the process themselves.
I mean, you
So
and I see
look,
this all the time. It's just,
You
unless
can't
you've been in
rely
that
on the other
position and you
party.
do it all the time, you don't know what to do.
Yeah.
And so
We see it every day with our clients. They're like, I had
Absolutely.
no idea what to do.
I see it with my own daughter who got involved in an accident in San Diego, and she was clueless.
Wait, did I represent her in that case? Or- I know I've represented about
You've represented
90%
most
of your
my
family.
involved in
And
accidents.
Jim is
yes.
related to every Filipino in Kern County. Is that right?
That's my mom.
And,
Okay.
and really, I don't look. I don't like to disparage insurance companies, but look, I've been
They're
dealing.
not on your side,
I've been
but-
telling clients for ever since I've been practicing. Insurance companies are not in the business of paying out claims. They're in the business of not paying out claims. That's how they make money. And unless you have any degree of sophistication, you're at their mercy.
Yeah.
And as an example, and I don't want to belabor this, but just as an example, let's say you've got a legitimate claim that's worth $10,000. Everybody would agree it's worth $10,000. And you go to the insurance company and you say, I'll settle my case for $9,000. Oh, that's too much money.
They'll offer you two.
Your case isn't worth anything near that. So,
If I can specifically address that question real quick, though, you know, what oftentimes happens, so you're in an auto accident, the at-fault party likely knows they're at fault, by the way. They may not admit that, but they know that, okay? Well, unless they contact their insurance company and report the accident, that insurance company is never going to reach out to you. They don't know the accident happened.
and Matt's absolutely right. I mean, sometimes the first time the person at fault's insurance company finds out about the accident
From us.
is when we send them a letter, because their insured never told them.
Sure.
And one other thing, and I understand how this happens. You get into an accident with another car. Let's say it's a rear-end accident. The other party at the scene goes, look, it's all my fault. We don't need to call the police. Let's try to take care of it. And then a week later, oh, you slammed on your brakes. It wasn't my fault. It's your fault.
Well, I've got that case going right now.
And so, people all of a sudden they start thinking about it, and then they kind of have a change of heart. So, sometimes it's just human nature.
Sure.
Well, it's not my fault. I don't want to accept responsibility.
Yeah, and again, I think it goes back to until you're in that situation, what do you do? And since we're on the topic of insurance, Matt, what would you say is what should people do as far as protecting themselves when it comes to insurance?
That's the very simple answer, especially in the context of auto cases. I mean, in our county in particular, okay, we have, if you're driving down, let's just pick a street, Chester Avenue, okay, and you look to your left and you look to the right, there's cars parked on either side of you. Odds are one of those cars either has no insurance or a $15,000 policy. And a $15,000 policy, and we all deal with this constantly, will likely cover the trip to the hospital and the emergency room visit.
And Matt, explain the significance of the $15,000.
Yeah, I think that's a good point. So eons ago, the state of California passed a law that required us to have auto insurance. Okay, now I get asked all the time, well, the law says you have to have auto insurance. Why don't these people have auto insurance?
Yeah.
And my response is, well, people break the law all the time, right? Just because we have a law doesn't mean everybody follows it. That being said, at the time they enacted that law, they set a state minimum requirement for insurance at $15,000 per person or $30,000 per accident. People get confused all the time. What's that mean?
Yeah.
So let me explain it. If there's one person injured in the accident, they can collect $15,000.
Up to a maximum.
A max of $15,000. If there are 10 people injured in the accident, they get to split $30,000. Okay,
And
That's
no
how it
one
works.
person out of that group
Can get more than 15.
15.
So that is unfortunately what a lot of people are driving around with, and it's just not enough coverage. We can argue with the law in the state. It's been that way, Dave. What, for 30 plus years now?
Oh, I think that's been the number since I've been practicing, which is 42, 43 years.
So you just think about that for a moment. When Dave started practicing, you could buy bread for a nickel. Okay,
Well, we
And
just
gas
we-
for 20 cents.
We just
that
went
probably
from,
isn't an exaggeration.
we
That's
just
true.
went from the horse and buggy to the Model T.
But the point is, we've had inflation since that time, but that law has not changed. It's been 15-30 since Dave started practicing, and so it's just not enough coverage. So your question: what do you do to protect yourself?
Exactly.
You buy uninsured motorist coverage. It's a coverage that you can have on your auto policy. That is the coverage that protects you if you're in an accident and that other driver, that at-fault party, either has no insurance or not enough insurance.
And the nice thing about uninsured motorist coverage is, number one, it's relatively inexpensive in comparison to what the policy costs. So, for instance, if a standard $15,000, $30,000 policy costs, let's say, $500 a year, to bump those numbers up to reasonable numbers, maybe $100,000, $300,000, it might raise the premium perhaps $100, $150 a year, but you're buying, both you and your loved ones, so much more protection than what you would normally have.
Sure.
And
And excuse me, people ask me all the time, well, how much insurance should I have? And look, it varies from person to person, and obviously there's a component in how much you can afford for the premium. But in this day and age, with the cost of medical care,
Yeah.
I mean, I would think a bare bones would be 50,000, 100,000. You're better off at 100,000, 300,000. And the way it's called uninsured motorist, but there's another component that's in that same coverage. It's called underinsured motorist. So the example is, let's say you have a case that's worth $100,000, and the party that is at fault only has $15,000. You then have the right under underinsured motorist coverage to go to your insurance company and try to get an additional $85,000 from your policy. And the other advantage to that is you're not in court for that. There's a totally separate proceeding for how that's handled. It's called arbitration. I won't go through it, but you've absolutely protected yourself and your loved ones if you can afford to have that additional coverage.
And George, real quick, I know you want to get to another question, but while we're talking about underinsured motorist coverage, I think it's important to point out that that coverage covers you even if you aren't in your car.
Yeah, actually, that's a great way.
point.
That's a great segment.
If you're walking down the sidewalk and you get hit, if you're in a parking lot and you get hit, if you're on a bicycle and you get hit, the only requirement is that the other vehicle made physical contact with you.
Exactly.
Okay?
So let me cut you off just there. We have about 9 minutes left. For those listening and watching out there, please comment.
Clearly talk too much for an hour,
Yeah,
right?
exactly, right. But no worries. If we don't get to you, we'll answer your questions for sure offline. And as always, free consultations at Cohn Stiles if you do have some sort of legal issue that you need help with. We do have some good questions out here. Some of them kind of tongue-in-cheek that I won't ask right now. In fact, even some comments, Mr. Cohn, you're the best out there. And I won't ask you this one because I'll put you on the spot. You got to pick your favorite daughter.
Go
I don't know
ahead.
if you want to do that.
I knew this was going to happen.
But getting back to that very important question, which is, we're really bad in Kern County when it comes to pedestrian safety, bicycle safety, and now the hot news is the birds, right?
Yeah.
The electric scooter safety. So what advice do you guys have for those people that are walking, riding their bike, riding these scooters around town to make sure that they're safe and protected as well?
Well, let me turn this over to our only bird
That's right.
operator.
Yeah. Earlier this week, Matt test drove one of those inside of our office.
Well, it's important to know how they
and he
operate.
nearly crashed.
So in answer to your question, your question is a little more complicated than maybe you meant it to be. If you're a pedestrian and you're walking, my advice to you would be, A, look where you're going. Okay, don't be down looking at your phone when you're crossing the street. I see that all the time, especially in downtown Bakersfield. And B, have uninsured motorist coverage, because if you're hit, then at least you're covered, right? I used to ride with my partner here, Dave. I used to ride bikes all over the place, and that coverage was critical to my family, because if I got hit while I was on my bicycle, the odds of whomever it was that hit me having enough coverage to cover my damages is probably slim and zero, right? However, my uninsured motorist coverage, even though I'm on my bicycle, covers me in that scenario. Now, real quick on the bird and bicycles, we have a huge problem in this county, and it's people they don't follow the rules of the road, right? If you're on your bicycle or if you're on one of these scooters, you are to follow the rules of the road. It's no different than if you're a car, right, Dave? We talk about this all the time. You can't ride the wrong way on the street.
And you can't ride on the sidewalk.
You can't ride on the sidewalk. Okay, you should be wearing a helmet, right? If you're under the age of, I believe the statute's 16, you have to wear a helmet.
Sure.
Okay,
It's a law.
Right, and so, there are things that you can do to protect yourselves. What I see in downtown Bakersfield, and I see way too much of this, is people, on a bicycle, on the sidewalk, riding the wrong way. Cars are pulling out and they're not necessarily looking at the opposing direction of traffic, right? And so that's where you see accidents. And so my advice would be follow the rules of the road.
And so often, even in downtown, people are jaywalking.
Oh, yeah.
Apparently, traffic signals don't have any significance for a certain element of our society. I had a fellow come into work this morning, decided to cross the street when it turned green for me, and it was obviously red for him. I mean, you just have to be alert to that.
Yeah, but the legal issue I think that is interesting that a lot of people don't realize is if you are following the rules, for example, in your neighborhood, walking, riding your bike, and somebody hits you, you are covered under your insurance.
Under your uninsured motorist.
Underinsured.
Absolutely.
I had a question for you, Matt, about uninsured, underinsured coverage, and that is this. So I use my car for business purposes, and it's a part of my employment, and I carry a big uninsured, underinsured policy. A Chevron tanker truck pulls out of a stop sign and nails me. So I've got a workers' comp claim, but how does the uninsured, underinsured policy protect me?
In your hypothetical, it probably doesn't matter because if a Chevron tanker hit you,
There's
in all
plenty of
likelihood, there's
insurance.
plenty of coverage, Jim.
Okay.
So I don't know.
Don't be looking to the firm's
Let me give you a
coverage.
better example.
Yeah,
And this
yeah,
is something that impacts. I'm going to talk about George for 1 second. George is so heavily involved with Mothers Against Drunk Driving. He does so much in the way of volunteering with that organization that we see a lot of drunk driving cases. And unfortunately, in most of those cases, there's either no insurance on the part of the drunk driver or very, very little insurance, right? And it's in that scenario where having that uninsured motorist
that's what
coverage
I was-
is absolutely critical, right?
Perfect. Any other questions, please, guys? Comment and let us know online. We'll be sure to get to your questions. If not right now, in the next 4 minutes, for sure offline. I'm just scrolling down here to make sure there's nothing we missed. I think we pretty much covered it there. Jim, is there any other important issues you think facing injured workers that people should know about?
I think the medical treatment issue is the one that is the most problematic right now. I mean, this is a sad state when correctional officers who get hurt on the job have a more difficult time getting medical treatment than the prisoners that they're guarding.
Jeez.
Because the people who are in state prison, they're guaranteed medical treatment. But in the workers' comp situation, the correctional officer is not guaranteed medical because it's still overseen by the insurance carrier. That's a sad state of affairs.
Yeah. So maybe something at the state level that people.
Oh,
should
I've
campaign about.
been arguing that the legislature needs to make a change.
By the way, you talked about correctional officers. Just to show you how workers' comp can work, I had a correctional officer up at Tehachapi who was in his car going out the prison. He hadn't gone through the gate yet. Was rear-ended
By a uniform truck, as I recall.
by a uniform truck. Was severely injured. Workers' comp. Third-party case, but workers' comp.
Gotcha.
Right.
We have about 3 minutes here. If we don't get your answer here in the next 3 minutes, that's fine. Call us 661-323-4000. Also chainlaw.com. We have a chat service that you can use as well. Spanish as well. Spanish speakers. In fact, we have a Spanish URL, abogados in bakersfield.com. In the next 2 minutes, anything that we've missed that you think is really vital for viewers out there to know?
Well, long story short, from my perspective, the more complex your situation is, the more you're going to need an attorney. But even if it's a simple situation, ask for the advice. It's always free.
Yeah, when in doubt, it's free.
Yeah, about half of the people that I talk to, either on the phone or in person, George, they may very well have a case. They may not necessarily need my help, right? It could be something where they are capable of handling on their own, and we can give them some advice, and that doesn't cost them anything to get that advice.
Yeah.
There are times when, I might refer someone to the small claims court, which, they have a maximum of $10,000. And in that situation, they very well could be much better off than having us handle the case.
Sure. So you heard it there. That pretty much finishes our segment here. I hope you all learned something along the way. Again, please, if you have any other questions, please reach out to us at our phone number 661-323-4000 or our URL chainlaw.com. Besides that, we have a team of 7 attorneys in our office, 2 of them workers' compensation, both of them specialized in workers' comp, and a whole full staff that's ready to help you, team of paralegals, team of staff. Anything I'm missing here?
The only other thing I might emphasize is this. When it comes to hiring an attorney and when you're trying to decide, okay, well, what would separate one lawyer from the next?
No.
I think what's really important is to know that the lawyer that you've hired to represent you is a lawyer that tries lawsuits, a lawyer that goes into court on a regular basis and tries lawsuits.
Can I add one thing to that too?
Really
A
quick.
lawyer that's local and meets with you in person.
Absolutely.
Right.
Very good.
Absolutely.
Very good. Thank you all for tuning in and asking some questions. I hope you learned something along the way. And again, chainlaw.com, 661-323-4000. Thank you very much.